Good morning. Thank you for joining us this morning. I am Laura Prowse with Kass Insurance Services. And for those of you who are unfamiliar with Kass, we have been providing real estate errors and omissions insurance and risk management services to real estate agents and brokers for over 20 years. We believe that every agent and broker should have the tools to succeed. So we hope you find today's webinar of value. And just so you know, we do offer these monthly throughout the year. So please check your email and look for our email blasts. This morning, we needed to have attorney Rinat Erlich of Manning & Kass talking about the risks that property managers face. We know it's tough out there. Rinat is a partner with Manning & Kass, and she co-manages the firm's professional liability practice. She's also a real estate broker and a legal malpractice specialist, and has defended many professionally in broker and property management and escrow. Rinat has been defending real estate professionals for more than 20 years. And in the last several years, she's actually been working very closely with Kass. She puts on risk management seminars for us, also writes articles and assists with risk management in general. So without any further ado, I'm going to have Rinat speak for a minute, and then I'll jump back in with some housekeeping items. Rinat, if you want to give a welcome to everyone, that would be great.
Hi, everyone. Thanks for taking the time to listen to me. As Laura mentioned, I am a trial attorney, so what I do most of the days is I'm in trial or getting ready for trial. And the reason that I wanted to talk about property managers is because I happened to defend a lot of property managers. I have not only tried cases, I'm also involved with the cases when they go on appeal. And I could talk a little bit about that as well. I could talk about how California is in terms of evaluating property managers and so forth. So I'll try to fit it all in 30 minutes, but if anybody has any additional questions, this is the first slide and it has my contact information. Feel free to email me, and this is my picture so you can imagine how I look like. Laura, back to you.
So before we get started, just a few housekeeping items. We are going to do a Q&A at the end. You'll see a Q&A button at the bottom of your screen. Feel free to type in your question as the webinar proceeds, and I will read them to Rinat at the very end. So Rinat, off to you.
Okay, so just to tell you how committed I am, I'm actually in the middle of a mediation on a lease dispute involving a commercial property around LAX, and I went into a separate conference room just to give this presentation. So seriously, property managers have a lot of risk. Now, if you're expecting this presentation to be sort of what to do as a property manager in terms of how to manage the property, so you're not in the right webinar, because I'm not an unlawful detainer attorney, and I'm not going to talk to you about specific forms and tenants' rights and so forth. What my goal is for you just to understand the risks, because every slide that we're going to go through has been one of my lawsuits. So I want you to understand the risks, and I don't want you necessarily to change how you practice. I just want you to understand the significance of what you do or what you don't do when you do practice as a property manager. So the first question in my mind is, are you even a property manager? I've had numerous cases where a real estate agent lists a property, sells a property, and then the buyer says, hey, can you manage it for me? I'm not ready yet to move in. Now, that would be a typical case, and the real estate agent now understands they're entering into a management agreement. But sometimes the relationship is a lot more subtle. Sometimes the buyer says, hey, you know what? I'm not ready to move in. Can you just list it for lease for me? Now the agent thinks he's a listing agent for a lease, not even thinking property manager. Then a tenant comes in, the tenant doesn't have a broker representing them, and the listing agent now writes the lease. So now they're taking a position as a fiduciary to the tenant as well. The tenant only knows the agent. They don't really know the owner. They have never dealt with the owner. A lease is created, the tenant moves in, and now they have their first issue. It's something happens, a leak or bed bugs or whatever it is. And then what does a tenant do? the tenant calls the agent because the tenant only knows the agent. And now the tenant calls and speaks to the agent and says, hey, I have this issue. The agent, being diligent, contacts the owner and says, hey, here's an email I got from the tenant. They have this issue. What do you want me to do? The owner responds, oh, I don't know any repair people. Could you just call somebody to go there and make the repair? And of course, the agent, again, trying to be helpful, says, sure, no problem. And then they call Joe Schmo to come in and do the repair. All this interaction makes this agent potentially a property manager. Take it to the next step. The tenant is late on making the payments. The owner calls the agent who leased the property and say, hey, agent, can you do me a favor? The tenant is not paying rent, they're late. Can you go pick up the check? Or I'm out of town, can you have them deliver the check to you? Sure, no problem, I want to be helpful. And now you're getting the money for the rent. Again, these scenarios are the most common that we see, where an agent doesn't even realize that he or she are property managers. They do not have a contract between them and the owner that says what the various obligations are of the parties and how much they're going to get paid and how to deal with things and so forth. So this is the most common situation. I don't know if the people that are on this webinar are just real estate agents that want to get into property management, or are people who manage portfolios of residential property or manage portfolios of commercial properties. I will try to give tidbits on all those just so it would respond to all of your potential interests. But again, feel free to contact me if you have more specific questions. So, wait, I'm still in that.
Yep.
Okay, so what is the problem when a tenant or a landlord think that you're a property manager and you think you are not? You don't realize that as a property manager, you owe duties. You mainly owe duties to the owner, who you act on their behalf. But if you are also managing the property, there is case law that says that you might also owe a duty to the tenant. What do I mean by case law? So in the legal profession, there are a lot of statutes that pertain to various industries, to real estate agents, property managers, and so forth. There's regulations. But what happens is a case gets litigated, a party is unhappy, and then it goes on appeal. When it goes on appeal, the Court of Appeal then decides who wins, who loses. There's always one party that wins, one party that loses, and it issues a statement of decision, an opinion. That opinion becomes law. So whatever the issue you have as a professional, an attorney can't tell you right off the bat what the answer to that issue is. They would have to research what cases are out there that sort of explain the statutes and so forth. So still on the first issue, to determine whether you're a property manager or not, case law has said that you have to look at the totality of the circumstances. You have to look at everything you did, and the more you do as a property manager, the more you are a property manager, even if you do not have a contract. And I don't know, Laura, if you want to go back to that original slide. What I had on the right of that slide is basically all the places where you could potentially be have a claim. So it could be the Department of Real Estate. It could be a consumer claim. There are all kinds of different legal entities that can make a claim against property managers. And mostly those claims will have to do with violation of the Fair Housing or violation of the American with Disability Act. So I do want to emphasize those two statutes and talk about them. So the American Disability Act is a federal statute. You would think, okay, well, if it's federal, then does it really apply in the different states? Well, yes, it does. It takes precedent. And what the ADA says is that it applies to public areas only. So if you manage commercial property, then the parking lot would be at stake and any of the common areas. If you manage a building, then all the common areas could be public areas. It could be the pool. It could be, if there's a little garden, whatever it is that we have with respect to public areas in a residential property. Obviously, if you are just a property manager for a single family residence, there are no public areas. So the likelihood is that the ADA will not apply to a single family. But like everything else with the law, there are exceptions. And I'll talk about that to the extent the time permits. Okay, now, an example to where the ADA will apply, I gave an example here of a parking lot. So you do have to have an assigned place for disabled tenants. If you have a specific, you don't have to have a specific place assigned to tenant number one if they're disabled. You should have a spot that should be available to anybody who's disabled and has come to the property. And a disabled spot has to be wider than a regular spot. And I've defended many property managers on those kind of claims where they manage a property and there isn't a designated parking spot for a disabled person. What is it that you really need to think of when you think about the ADA? Just think about accessibility. That's why I have that at the top of the slide, because accessibility is the way of the law to make a property equally available and accessible to everybody. If it's not accessible to a person who's in a wheelchair, like in my picture here, then obviously you're treating that person discriminatorily, because you're not treating them the same as somebody who has legs and can hop on the stairs. So what other issues could be considered barriers? For example, if you have alarms that are flashing, you have to have lights, because some people have our difficulty of hearing. They can't hear if it's just screaming. If you have narrow doors, it could be considered inaccessible for people with wheelchairs, or it could be something simple like high drinking fountains and so forth. So I'm not expecting you to become experts in this from a 30-minute presentation about ADA, obviously. I just want you to think about the ADA as something that is out there. And I also want you to be cognizant that there are attorneys who specialize in suing landowners and property managers for ADA violations. There's some issues with the statute as to who has to pay the cost of converting it to ADA accessible. So if your landlord buys a building that's older, from the 80s, obviously it's before the law was instituted, then it really depends. Sometimes the law would say that if the tenant would have to convert it, and if it's a significant cost, like if it's structural. So for example, let's talk about a commercial property. You have a restaurant on it. The restaurant itself has to be ADA accessible, assume bathrooms. It's a public area, bathrooms should be accessible. Well, who should convert the bathrooms to be accessible? Obviously the restaurant owner. However, this is very important. If the landlord is sued because a restaurant guest did not have accessible bathrooms, then that's permitted. So the guest of the restaurant is not limited to only suing the tenant. They can also sue the landlord. And what does that mean? That I don't know if you have access to the prior slide. You might have access to it in the future, but it was a slide about a lease. And what I mentioned there is when you're a property manager, you handle the lease. You either propose it and you deliver it, obviously. You want to tell your landlord, your client, that there are issues that they should be cognizant of, and they may want to put it in the lease. Now, by no means am I suggesting that you ever draft the lease, draft clauses in the lease, any revisions whatsoever. I can't tell you how many cases I've had where my clients were blamed for drafting something improperly. You're not attorneys. You're not expected to be attorneys. And in fact, if you do attempt to draft something, you could be sued for acting as a lawyer without a license. But you do have to have that conversation with your client and say, look, I think there's some ADA issues. I'm not an ADA expert. I think you need to hire an ADA attorney to look at the lease and see what provisions should be there. For example, you might want to have the restaurant owner, who is your tenant, to have an indemnity to protect you and defend you if there's a lawsuit about ADA, and you definitely want to potentially make those the restaurant ADA accessible. Okay, Laura, you can move to the next slide.
Okay, I'll do it without hopefully screwing it up.
Okay, so what do you have to do in terms of accommodation? We're still talking here about the ADA. You have to accommodate the tenants, but again, it has to be reasonable. And obviously you're just a property manager. It's not going to be out of your pocket, but the owner needs to understand these are some of the things that they're going to have to do. I have this little picture here that shows sign language, braille, wheelchair, hearing, eye. I mean, these are all the disabilities you're going to have to think of. There have been new lawsuits, I would say, in the last 6 months about websites that are not accessible to certain disabilities. I don't know how large, again, if you're a large property manager, you might have a website that advertises your services and so forth. There are rules with respect to websites and what they have to have as far as accessibility. You have to have their links where somebody who is like, for example, if you have a video, so somebody who's hearing it, has difficulty hearing could be able to receive a translation, or somebody who can see that they'll be able to hear and so forth. So these are things, again, I'm not going to sit here and tell you how to create that website. I just want to give you an idea that that is an area of exposure and that I've seen lawsuits about that issue. I wrote here that this might include financial accommodation, and I'll give you an example. Let's say a tenant is living off of some sort of disability payment, and the disability payment comes in every month on the 8th, but their rent is due on the 1st. You will have to accommodate that tenant so that they'll be able to pay rent on the 8th. So again, the accommodation is going to have to be reasonable, but you're going to have to do it. You can move to the next slide. Okay, I have a special slide for pets simply because I have several risk management hotlines that I manage, and I get a lot of questions about pets. Unfortunately, pets are allowed under certain circumstances because an animal can be either a service animal, a guide animal, but where you get into the real gray area is being an emotional support animal. Everybody has emotional distress these days, and everybody has issues, and everybody needs their animal. The question is, and again, you look at case law to see what case law has said about this issue, is where do you draw the limit? There was a case, for example, where a tenant said, I want to have snakes. I'm attached to my snakes. Okay, well, if it's a snake that's poisonous, obviously it's dangerous, and you cannot danger other tenants. That is obvious. So I think in that situation, even if the tenant wants to argue that that's an emotional support animal, there would be an argument that it dangers other tenants. So again, it's I can't tell you what the answer is because it depends on the circumstances, and B, it depends on what kind of law is out there with respect to the specific situation, specific animal, and so forth. As far as asking the tenant for a certificate, again, it doesn't have to be from a medical professional. It could be, hey, I'm the professor of the student, and I know them. They had a emotional breakdown, and they really need this animal as a support, and so forth. So it's really an issue where somebody could raise the issue, and then now you're faced with, okay, what do I do? The path of least resistance is just allow the animal in. I mean, that's really the easiest thing. So unless it's kind of a snake or a dog that bites or barks at all hours of the day and is a complete nuisance, then I think it's just simply easier to allow the animal. You have to be careful. Where you could get in trouble as a property manager is that usually the property manager is the one that makes these decisions because they interface with the tenant. So if you advertise pet-free property or you talk to the tenant and you say you can't bring your animal, then now the landlord may be sued, but they are sued because of something you have done on their behalf. This is where you can get in trouble because you're taking an action on behalf of the owner. In the perfect world, you may want to consult an attorney, but I don't know that people would do that, but definitely it's an issue. You could go to the next slide. Okay, so another statute that comes up with respect to property managers is the Fair Housing Act. And the Fair Housing Act basically says that you can't discriminate. It's not exactly like the ADA, because the ADA only talks about disability, where the Fair Housing Act talks actually about other protected classes. The protected classes are sex, religion, national origin, obviously disability. So the question is now, what is it that you're doing that may pertain to one of those classes? I gave an example of Social Security because I had that come up. Social Security, you as a property manager, obviously you want to get the Social Security of the tenant because you want to check their credit. A best case would be to have the tenant create, get their own credit report and give it to you. There's always a risk in that, and I've had those lawsuits as well because they might pick and choose. It might not be a full report and so forth. But the risk that I'm talking about here is that some people don't have Social Security, and that's where discrimination comes into play. Now, there are a lot of local statutes as well. So even though the Fair Housing is a federal statute like the ADA, there are some local statutes in California that may affect national origin. And you know how California is a safe harbor state, and it doesn't want people, landowners, property managers, to shoo away potential immigrants who may not have paperwork. So we want to accommodate all those kind of people. And then when you ask for Social Security, that could be discrimination against national origin. You could go to the next slide. So this is just a summary of what we talked about. Since we don't have a lot of time, I wanted to, we just talked about it, so we'll move to the next slide. Okay, this is another example of discrimination. You can discriminate against familial status. So somebody who has kids and you say this property is not for kids, or if you say kids cannot run around, or you say no bicycles or skateboards, and usually kids are the ones that use bicycles and skateboards, it almost starts sounding like you're discriminating against kids. If you say, no running, making noise, and so forth. Again, I can't tell you how to do that. I just have to tell you to tread lightly. You may want to consult an attorney who is an expert in fair housing and say, okay, how do I do that? There are occupancy limits as well. The typical one, the standard is 2 tenants per room. And again, when you talk about some of these homes out there, especially in areas where are low income, we have a lot more tenants in units. Again, even though the housing standard is one thing, discrimination is another. And you might be facing discrimination if you say, I can't rent to your family of 8 people because this is a 2-bedroom home. That may be a problem. You could go to the next slide. I mentioned here harassment just because it's a form of discrimination. So for example, if you have a tenant with a mental disability and they're wacko. And you may start harassing them. If they are, for example, if they're hoarders, and you try to evict them, or you try to cite them, or anything like that. I'm not saying you need to accept hoarders. I'm just saying it is a judgment call. All these things I'm telling you are judgment call. Nobody's going to give you an accurate assessment of what a result is going to be, because there's always going to be two sides. The tenant will present their side. A judge is going to decide. A case could go on appeal. But that is something you need to think of. Be very careful. Tread lightly. I think that is the theme of this presentation. Tread lightly. Judgment call. Be careful. Be cognizant of those issues. So definitely, if a tenant is a hoarder and you're starting having a lot of bugs around the house, or cockroaches and so forth, maybe you could say something to that tenant. So again, just be careful. You could go to the next slide. Okay, we just talked about that. Let's apparently Laura wants us to talk about deposits. Okay, so this is a big deal. I can't emphasize that enough, and I'm sorry for being so vocal about these issues, because I've had class actions about deposits. It's a little tiny thing where you just send the tenant back what they're owed, but if you don't do it exactly like the statute says, there are attorneys there. Let me clarify. There are 150,000 attorneys in California, and just do the math. So these attorneys need to be busy. And these attorneys are going to make claims, and they're going to make claims that are advantageous claims. And this is one of them. Why is it such a great claim? Because if you don't comply with the statute, boom, that's it. You're at fault. And the statute allows for punitive damages, that's treble damages, and it also allows for attorney's fees. So an attorney can file a claim. I had one where the property manager managed 900 units, and they filed a class action on behalf of all the units. And now they can go back 4 years. And if you go back 4 years, plus the years that the case is in litigation, that's another couple years. So figure out 6 years of tenants rotating in those 900 units. So that could be, I don't know, thousands of tenants. So you want to be careful. What is the gist that you need to know about deposits? The basic is as follows. You need to give the tenant a notice that they have a right to inspect before they move out. So you walk with the tenant to see what's wrong. And then the tenant has a right to repair it. And then if you end up repairing it, you have to send the deposit back within 21 days. It is very important to send back the deposit, but attaching all the receipts of the repairs that were done. So for example, if you had a painter, attach the receipt from the painter. If you had somebody fix the windows or the screens or whatever it is, you need to attach receipts for those. If you have a handyman that's on your staff, what you need to do is you need to write in that deposit receipt that you return to the tenant how much your handyman is making per hour and how many hours they work. The idea behind providing the receipt and the hourly rate of the handyman is so that the tenant, there's not going to be any gouging. There's not going to be any amount on top of it that the property manager or the owner is getting. So because it's a deposit, you're holding it as a fiduciary. It's like an escrow company. So you're allowed to deduct, but it has to be very precise. If you have a receipt but you don't have the exact amount because the vendor has not yet had a chance to go into the property, then you provide the estimate, and then once you get the full receipt, you send that to the tenant. You could go to the next slide. Okay. Late fee, just quickly, it has to be part of the lease. You can't just charge late fee just because you want to. It's whatever the lease says, and it has to be the actual charges. So if the bank charges you something, or maybe an interest on the money, and it has to be reasonable. It can't be something egregious like the amount of the rent or something like that. And again, one thing to keep in the back of your mind is there's a cause of action. So if you get sued, whoever sues you, let's say the tenant or a third party, they're going to make legal claims. They can say you were negligent, or they could say, if it's the landlord, they could say you breach your fiduciary duty because you're a fiduciary of the landlord. If you have a relationship with them as a property manager, it could be a third party, and they could say that you misrepresented something, maybe on the advertisement of the lease. So there are all these potential legal theories. The facts are going to be the facts; they're not going to change. But the people who sue are going to put them into these labels that are going to be the legal causes of action. So one cause of action that's typical is called unfair business practices, and it basically includes everything. So anything that you did in a violation of the law that was unfair, gouging, anything like that would be unfair business practices. Under that, they could get their attorney's fees, and the statute of limitation is 4 years. You can move to the next slide. With rental increase, it's just a tidbit that I found that recently. You're not allowed to increase rent when there's a state of emergency, and it could be a city where something happened, like if there was just fire in this county or something. Thought it was interesting. Again, these are things that I've learned over the years when I've had lawsuits on these issues. You could go to the next slide. Bed bugs, a really fun topic. There's actually a statute that deals with the disclosure you need to give. Just look up the statute. These statutes are really, really simple to read, and if you read it, you could follow it. You can't always charge the tenant for it, because if the bed bugs came from a tenant next door, maybe they brought in the sofa that had all these bugs in, and now their bed bugs somehow got to this tenant who's now making the claim. Obviously, they're not responsible. So you really need to pin the tenant as the responsible party if you want to claim that they are responsible for the payment. Yeah, you could go to the next slide. I bring up cannabis just because it's a really big hot topic, and it's really fun. Obviously, the law is changing constantly about it. I get calls about it as well. I want you to be careful. If you are leasing a property for the use of cannabis, of growing cannabis, just know this, that the laws, okay, let me start back. Federally, it's still a crime, which means that the property owner can be sued by the federal government. And the way the federal government can pursue the property owner based on statute, and this is a whole presentation in itself, is by basically taking over the property. They can take the property from the owner. So that's a really scary thing. The state obviously allows for cannabis, so they might comply with state laws, but the state has been changing its laws. I think in the last few years, the laws have changed like 3 times. So what they change is the licensing. What does it require to license? And what they've done is they divided the license into the categories of if you're a grower, if you're a distributor, if you're a seller, if you're a retailer, if you're a wholesaler. The person who is renting the property, let's say it's an industrial building, are they going to be a grower? Are they going to be a distributor? We don't know what they're going to be, and their licensing are going to be different. So obviously, you can't tell your owner, the property owner, if this is a legitimate business, even though the state allows for it, because you don't know if they're paying taxes, you don't know what the licensing requirements are. So first of all, I want to tell you that you have to be really careful with cannabis, because the owner could be responsible. So now, if you're talking about, again, I don't know what type of property managers you are or may want to be. So if it comes to a tenant that wants to smoke, if it relates to disability, go back to what we talked about, ADA. This tenant has whatever, cancer, and they need to smoke to relieve pain. I wrote here, consider a smoking-free environment. I think that is acceptable because, again, in terms of accommodating the tenant can chew on pills or gummies, or I don't know what is out there, but I'm sure there are other oils, things like that they can do that is not smoking. So maybe you can't prevent the tenant from using cannabis, but what you can prevent them is from smoking. I mentioned here things to worry about, and what I want to say is the following. tell your owners, if this is a commercial cannabis lease, that there might be issues with insurance, because the insurance that the owner has, okay, let's say this is a business that grows cannabis, there's a fire. This typical commercial lease says that the tenant is going to be responsible and going to have insurance. This tenant may not be able to have insurance because a lot of insurance company won't insure cannabis business because it's still illegal. The tenant might not be able to also have a bank account and pay with checks. There's some movement in that, but again, banks are a federal institution, so they're not really allowed to have bank accounts for a cannabis business. And if they do, then they have to report it. And a lot of tenants, obviously, they don't want to report to the federal government that they're in the cannabis business. So you have to be very careful. I wrote here eviction based on violation of law. This is just a tidbit to tell your owners. So if they're leasing to a cannabis business, they absolutely need an attorney. And what they need an attorney to look at is that the typical clause in a lease that says we can evict you if you're in violation of the law may not apply here if all the problem here is nuisance. Let's say the tenants next door are complaining about noise or about smoke, or I don't know what, toxins or something. It may not still be a violation of the law. Your owner may want to have the ability to do inspections regarding compliance, but it's a catch-22. Actually, you could go to the next slide. It's basically, I wanted to mention, a catch-22 is that if you're going to do inspections, then you have to know what you're looking for. And again, you're not a lawyer, you're not a cannabis specialist. You may not want to take that responsibility in doing inspections to make sure that they comply with the law and they're using the permitted use that allows in the lease and so forth. Anyway, the most important clause in my mind is indemnification, where the landlord will be indemnified by the tenant if there is an issue, especially because if the federal government comes in and takes over the property under the forfeiture statutes, there's no insurance that's going to cover for that. And then the other is the early termination. If there's really a problem, the landlord is starting to get fines for odor and loitering and things like that, they may want to terminate that lease. You could go to the next slide. Justification rental, want to make sure there's nothing that forbids that, and make sure that the lease would not allow it if you don't want the renter to be able to do it, or if you don't mind, that's fine. Just let your landlord know that's a possibility. And you can go back, next to my last slide, and I just wanted to finish with this. And again, I told you I'm going to hit the main issues for property managers. Well, guess what? Mold is a big one. We still see it. We see it all the time. We see tenants who are complaining about, oh, the property manager didn't disclose a prior event, or here's a leak and there's mold. There's attorneys out there that look for those tenants who have issues. And people in their mind think of mold as being a moneymaker, because they think, oh my God, I could get all my personal property replaced because it touches everything. I could get all my medical expenses. It's awful. There are a lot of defenses to mold. If you have a mold claim, just call me. I'll help you out. Most experts out there that talk about mold are just kind of wacky, and they're not very credible. But be careful, again, tread lightly. This is the theme of the presentation when you hire somebody to come in and do these remediations, because you want to make sure that you want to hire somebody who understands what they're doing. For example, there's a mold in a certain area, and somebody who comes in there has to close out the area. They then have to certify that they've done it properly. I've had many cases where a handyman goes in, they spray some chemical on the mold, they wipe it out, and they say, boom, done. Well, the mold comes back. Obviously, it comes back. So just think about that, and then think about the claim just being a very big claim, because now you have to pay the tenant to move out, or maybe to stay at a hotel, and that the claim may involve on personal injury, property damage, not just rent. So I think that's the last slide, Laura, right?
It is now. It's Q&A time. So we do have a few questions that have been typed into the Q&A box. So Rinat, if you don't mind, I will go ahead and read some of those to you, and we'll wait for some others. And thank you. That was really, really informative. We'll start with the first question right now. Who does the ADA apply to? And specifically, someone asked, does the ADA apply to 2 to 4 unit properties?
Okay, so
first question, who does the ADA apply to?
yes, so the ADA only applies to people who provide public accommodations. That would be a retail, a service, a business, and office building, warehouses, factories, places where you expect the public to go into. If you are managing a big residential property, and there are a lot of visitors who would come to see the property, I could argue that that's a public space because people can walk over and into the common areas. However, I talked to you before about the website. Your website is a sort of a public accommodation, if you will, because the public is invited to go on your website. So the ADA will apply to your website.
And how about, does the ADA apply to 2 to 4 unit properties?
It does not.
It does not. Okay. We have a lot of questions pouring in right now, so I'll get through these as I can.
But wait, I want to say this, Laura. Sure. The fair housing may apply, and disability is one of the things that you can't discriminate against. So even though you might not be violating the ADA by not accommodating a disabled person, you might be violating the Fair Housing Act by not accommodating a disabled person. The Fair Housing Act requires you to only provide reasonable accommodations.
Okay. I have another ADA type question. It just popped up. Do you need handicap parking for older pre-1978 apartments with 12 or less units? I know that's a very specific question, so I'm not sure you have the answer to that one.
Okay, so this is where I'm going to have to guesstimate because I'll have to research it. My guesstimate is yes, because if it's a parking lot that allows people to go in and out, and the accommodation is very, very inexpensive and simple. All you have to do is very simple, is take one space, make it a little bit larger. That's it, and you're done. Very simple.
Okay, I have another type question for you. Does the fair housing apply to all types of accommodations?
No. So the fair housing is not applicable to fewer than 5 apartments if the owner occupies one of them. Okay, so it won't apply to single family and so forth. It doesn't apply if there's no broker involved when the property is rented. So for example, if an owner just wants to advertise something that's somewhat discriminatory, put on Craigslist, I'm leasing my unit and I don't want any kids, the fair housing won't apply to that. It doesn't apply to religious organizations simply because one of the things you can't discriminate against is religion. So obviously, if it applied to religious organizations, then they wouldn't be able to do any business. So it doesn't apply to them. It doesn't apply to private clubs. It doesn't apply to senior housing. Again, they have to comply with all the statutes to be considered senior. But if it's a senior housing, then guess what? It's senior housing. So yeah, these are the main exceptions. But if it's anything more specific, I will probably have to research it.
Okay, I'm going to try and lump these together because the questions are pouring in here. So I have 2 on leases. For a residential lease, is a 5% late fee charged? Okay, can they charge a 5% late fee if rent is more than 5 days? Is that considered reasonable? So 5% late fee.
I don't know the answer to that because I'm not an unlawful detainer attorney, so I don't get involved in the nitty-gritty. I could tell you this, that there are rent control statute, depending on what city you're at, and all kinds of local statute that may be applicable in addition to the civil code. So you would have to research that issue. And like I said, the late fee has to be reasonable, and it has to be what you actually lose, if you will. 5% to me sounds excessive because depending what the rent amount is, because if somebody is late by 2 days, then what did the owner really lose in terms of cost? So you can't top whatever the actual cost is with let's call it penalty. So it can be penalizing. So hopefully that answers your question.
Okay. I have another one. Is an early termination fee, is that legal if you have that in the lease? Can you write an early termination fee in the lease?
Okay, so anything that the straight answer is yes, because anything that that the landlord and the tenant agree to is generally legal unless they agree to, I don't know, have this property as a whorehouse or something. I mean, you can't agree to engage in some criminal activity. So if the parties agree that there's going to be something and it looks like it's a mutual agreement with some mutual, so both of them can terminate early, not just a tenant, maybe also the landlord, and then the fee would go both direction and it doesn't look like a penalty, then I would guesstimate that it should be legal. So again, in all these questions, because I don't know how many questions we could get through, use common sense. You can't, okay, starting off, don't give your clients legal advice. The answer to all these questions, if it's asked of you, is going to be, I don't know, we need to hire an attorney and ask. That would be your first answer. Your second answer is going to be, or maybe the guidance is going to be, look, it can be punitive. So, and that's why, for example, deposits and all those, they can be punitive. So if it's something that doesn't look punitive, it looks like reasonable. I'll give you an example. When you have a contract and somebody breaches it, the party that is injured has a right to compel the performance or compel what they would have gotten out of the performance as if the contract was completely performed. So if a tenant leaves early, basically they're leaving the landlord now high and dry, and they need to go and rent it. So they're going to have to clean it up. They're going to have to advertise. There's going to be downtime. Maybe now they're going to rent it for less per month. So there's going to be a deficit there. There's definitely, let's call them breach of the lease type damages. If an early termination fee is like a liquidated damage clause, if you will, then there are rules about that. It can be too excessive. But then if the tenant pays that, they're done. The landlord can't sue them. So hopefully that kind of gives you an idea of where I'm going with this. You have to look at it, the context of everything else that's happening. It has to be in lieu of the landlord being able to sue for damages. It can't be a penalty. It has to be an amount that's reasonable, that the parties anticipate would be the losses of either party by that early termination, and so forth.
Rinat, just to let you know, I have about 20-something questions coming through because we have over 100 people attending. Obviously, everyone, I'm sorry we cannot get to all of these. We will, I will save the questions and we can address them and send out an email with the answers. They're excellent questions. Unfortunately, I know Rinat needs to get back to her mediation, and I know you all need to go sell property. So we are going to write down these questions. We will get the answers. We will send them out along with a copy of today's presentation and the PowerPoint slides. So I want to thank you all for attending. An extra special thank you to Rinat. She is extremely busy, and I'm so happy that she was able to pull this off while attending a mediation. So thank you, Rinat. Very informative presentation. And thank you all for attending. I'm very sorry we didn't get to all of your questions, but we will get the answers to you and we will send them out. We have all of your email addresses. So again, thank you, and thank you for attending. And please look forward to more webinars. We are offering these every month. They are in different states, but we have another one coming up in California in April. Thank you again, and all of you have a wonderful day.